sending it back to us in a letter, this does not comport with my wishes due to this, please change this quadro. She crossed it out. There was a letter to both Mr. Clover and myself that said, hey, I crossed it out because y'all didn't agree to it. Here you go. And that's it. And we asked, and we didn't realize there was a separate property issue by changing it. We didn't have the issue about it not being effective at all until after we filed the notice of appeal to the Court of Appeals. So the trial court.
Why won't you all just sign it and TMRS will accept it?
Well, now there's a disagreement. Again, we have the Rule 11 agreement, Your Honor, and the way it's set up is credited service takes, the appellee was married 5 times. The first 3 wives are back in the first 18 years of his service. My client is the last 18 years. By using credited service, they bring in income from when they weren't married to average. It's a month to month. Credited
income,
service.
it's years of service.
Well, it's years of service. However, it's based on the wages. Your contribution is based on your wage. So as a rookie patrolman, you might be donating or contributing $1 a month. But when you're the police chief, as the appellee is now, he's contributing $100 a month, but they're wanting to average that to $50.50 instead of, we're going to start the day that you were married. Now, I've spoken to TMRS Legals, like, listen, there's some ambiguity here. Basically, you're looking at 2 places where the dates that they were married matter in accumulated. In credited service, month is a month is a month. 20 years ago, 4 years ago, next week, they're all the same. They're all the same benefit amount, or they're all the same worth, and that's not right, especially if you look at the first 3 wives. If they were able to do credited service, that means they would get credit or an average of his last 18 years when they were married, and they were married 25 years ago. So it's about bringing separate property in. Appellee said in his brief, hey, this is just so we know how to calculate just for the time they were married. I agree. The credited service takes into account before they were married. And that's a separate income issue, that's a separate property. And short of faulting the divorce, is violating separate property principle.
When did you object when you noticed the court had amended the quadro to use the credited service as opposed to accumulated contributions? When did you object?
It's already been filed, but it was brought up in both of those.
Okay, so in both your motions that you filed that I reviewed, that's when you first objected to the courts using a different formula than the one that you claimed you and Mr. Clover had an agreement about.
Yes, we had we met the judge in chambers when I was on my second witness, and that was the appellee. She said we're going to take our morning break. We were notified, one, that the decree did not cover retirement, and also that we would be drafting the quadro. When we also, at the conclusion of trial, she had us come up, told us the same thing. Y'all going to work on the quadro. So there was no direction other than, hey, I wanted to include contributions and the interest, which accumulated does. But in my research, there's a difference. And again, it's kind of ambiguous. Mr. Clover and I were talking several times that TMRS doesn't do attorneys any favors.
But TMRS does provide the 3 different formulas that are available for a court to use, and one of them is accredited service. In my position, your client benefits from the city matching the longer that Mr. Hartley is in this position. Does she not?
No, Your Honor. It's a matching. However, doing one of my exhibits, in fact, I believe it's Appendix 7, it shows the calculation from TMRS. There's a $300 difference a month.
Yes, but that's now. But if Mr. Hartley continues to work for, let's say, 10 more years, the city matching will be input into TMRS retirement, and the number of service is going to increase, which means the ratio will go down and the payment will be higher.
But the same thing with wife 1, 2, and 3. I don't think it's fair for my client to later say, hey, I want this separate property income, which is after he was married, especially his new wife's going to be saying the same thing. So it's a slippery slope. Don't want to allow the separate property calculation to come in now and then have an issue with it later. It might be a de minimis issue now, but it is separate property income. We're violating separate property and the principle. So we are bringing in income from when Ms. Saunders and Mr. Hartley were not married. And just by the letter of the law, we want to keep that separate property principle intact. So the accumulated contributions is the correct way to go.
I know we're out of time, but I want to make
Yes,
sure
Your
I
Honor.
ask you this one quick question.
Yes, Your Honor.
What is your authority for that position? That the credited service method is not appropriate because of the separate, you allege that the income will be considered separate property?
Appendix number, besides the email from TMRS rep, appendix 6.
That was in the email from TMRS? That exact mention that it's considered separate property?
No, that was a discussion with TMRS Representative Veronica Mendieta and TMRS Legal as late as yesterday. But also in their pamphlet, appendix number 6 that I've supplied to y'all highlighted, it specifically says the accumulated contributions are contributions and interest credited during the marriage. And as part of the formula, contributions during marriage versus the credited service method, for the total number of months of credited service is averaged in. They were married 18 years. He's been, I believe he said 41, but I calculated 36 years. He's been a cop forever. So it's only half of that should be calculated in, and we're willing to let the chips fall where they may, but accumulated contributions is where this belongs. Now, if they married the entire time, okay, then the credited service. But again, if we allow credited service now, then we're opening up this for later for the other 3 wives to come back when he retires and to say, hey, well, I want credited just like she got credited, and they want the benefit of the last 18 years when he was a higher rank and made higher contributions.
Thank you, Counsel.
Thank you.
And if it pleases the court, I'd just go ahead and take my whole 15. I think I'd ask for 10 and 5 since I was a cross appellant, so take the whole 15, use my whole 15 now.
Yeah, go ahead.
May I proceed?
Yeah.
May it please the court, my name is Josh Clover, and as you know by now, I was trial counsel for the appellee and as well as handling the appeal here. There's a couple things I'd like to go over to address of what we just covered before I discuss if the court would like to entertain any of the issues I raised in my cross appeal. The most important thing I want to talk about that you just discussed with the appellant is the vast majority of the discussion that has occurred has been about documents that arose after we tried the case, and a bunch of documents, most of these are not most, but maybe many of the documents that are in the appellant's appendix are not part of the appellate record. They are documents that came from TMRS afterwards. They've never been introduced into evidence. There were some of the early emails attached to either the motion for reconsideration or the motion for new trial, but I think it's important for the court to be cautious of how much it relies on these documents that are outside the record.
Would you speak to what, in your mind, the significance of TMRS? I'm going to get the initials confused. Even is, why do we care what they think?
I tend to agree, Your Honor. And for this reason, I think what's before the court is the court either going to affirm the trial court's decision about what method are we using for the quadro, the accumulated service method or the credited service method.
It depends if you all had a Rule 11 agreement, which you signed. So if the court did not follow the Rule 11 agreement, then wouldn't that be a problem?
That would be a problem, and I don't disagree, Your Honor. And to be clear, at the trial court level, you know, myself and my client both didn't have much heartburn one way or the other, whether it was accumulated or the contributed service method that was used. It does result in slightly different numbers. Like everything else I've ever dealt with retirements, and I consider myself smarter than the average bear, it's fairly opaque how those computations are made with any retirement system has been my experience, and TMRS in this case in particular maybe. And those numbers could very well, as I think you yourself pointed out earlier, could be different 3 years from now, 5 years from now, 10 years from now, whatever those numbers end up being. And I don't think that the law says, and if it does, I need to change what I've been doing for 20 years, that when an order is signed or approved by council and it's as to form only, I think the law has long been that that does not constitute an agreement as to the substance of that order.
So why not just say that? When you received the quadro, instead of documenting, signing it as to form only, why just say we don't agree to what's contained in the document? Then we wouldn't have this issue as to whether or not the court followed the Rule 11 agreement or not.
Well, and to be clear, Your Honor, are you asking me why we didn't write, we don't agree to it on the order itself?
No, I'm trying to understand the signature on the quadro by your client and yourself.
Oh, to be clear, and I'd have to look at the record, I think it was only the attorneys that had signed at that point when it was submitted to the court. To me, it was a non-issue at the point. I didn't agree with it. Part of my issue was, and why I didn't do it, and I never do, is I didn't agree with what the court did on the retirement anyway. I couldn't find a case to brief for you and make it a point of error, but I didn't, so I only signed it as to form, which is what, there's a pretty good body of case law out there that says if you sign as to form, you agree as to the form of the order, but not the substance of it. And like I said, Your Honor, frankly, this wasn't, if she signed off on it one way or the other, I wasn't going to be too heartburn about it because I had already lost in my mind when she said, well, she's entitled to half of it. It wasn't divided in the divorce, and it's here for me to divide post-divorce. So I wasn't trying to pull a fast one on anyone or anything like that. I mean, and I'll be the first to admit, myself and Mr. Dunbar gone back and forth in some email. Hey, what should this look like? We'd both read the final judgment. I'll concede to the court today, I didn't really read the final judgment the way the trial court judge did either, and I think that's why I had said fine on the accumulated contributions, but I certainly was trying to make clear that I didn't want to put myself in a position that if I found out later on appeal that I did have some point of appeal on the underlying substance of dividing the retirement account at that point. I didn't want someone to come along and say, because I've had this happen to me before, wait, you've already accepted the benefits of it because you signed as to form and substance on the quadro.
So you will concede that the trial court's division of assets was just and right?
No, Your Honor.
Aside from the $39,000 judgment against your client, let's set that aside.
I'll put it this way. I mean, I guess I may as well concede the division of the retirement. I didn't raise a point on appeal for it. So as far as that goes, I don't disagree with that statement, Your Honor. And we certainly have our cross appeal on the other issues, you're correct. But that's how we got to the point that the quadro was signed as to form only. And frankly, I didn't think too much about it at the time when we still had to submit it to the trial court. I think we were both surprised when we got back the trial court with a letter sort of ruling to us saying, hey, that isn't what I meant in the final judgment. I've reread that thing a million times. I don't know. One other point I'd like to touch on this, other than the fact that we're talking about a ton of things that are post-trial, post-motion for a new trial, post-motion for reconsideration, items that are in the appendix but they're not in the appellate record. Besides all of that, I disagree, and you, again, Justice Ante, you asked the question to Mr. Dunbar, well, what is your authority that the contributive service method leads to necessarily dividing separate property? And I honestly don't remember exactly what Mr. Dunbar's answer was. Something about that's what TMRS said, or he read the form. I disagree with that, and this is a point I briefed in my reply brief or response brief. I think when you read, and it's very clear, and for what it's worth, I think it's clear in the trial courts, both final judgment and the way the quadro is drafted, it says when you look at the credited service method that you multiply whatever the number is you compute, there's a blank there, by the community property ratio, which is computed elsewhere in the form, it's not really an issue here, based on total creditable service between the following dates. And there's two blanks there, blank and blank. Those dates are necessarily, and what the trial court did here, those dates are the dates of the marriage. So I don't understand the appellant's argument that somehow that means that we're somehow dividing separate property of any party for that matter, but it'd be my client. I don't understand how that gets us to the point that we're dividing separate property, and therefore it would follow that that's an improper, division of separate property. I have one other issue.
I'm going to ask you the same question that I asked Mr. Dunbar. Was the court bound to follow the Rule 11 agreement that was signed by all the parties?
That presupposes that I agree with part of that statement, Your Honor. Assuming that that was a Rule 11 agreement, I think the law is fairly clear, particularly in family law matters now, that the court doesn't have a lot of leeway to vary either from a Rule 11, but most particularly from the funny, or I call them funny because I'm a civil guy, but the typical non-revocable mediated settlement agreements you can get to under the family code. There is some case law out there on Rule 11s, but it's always something that as it applies to children, and there's some really egregious facts as to those. You place the children with mom's murder or something, literally those sorts of cases. Presuming it's a Rule 11, I think the court had to do what we had submitted to the court. On the other hand, I don't know, and I haven't looked up because I really don't think it's a Rule 11, and maybe I should have put more time into that. But on the other hand, this situation is a little unique in itself. When you look at all those Rule 11 cases out there, those are cases where the parties reach a Rule 11, typically to settle the case, then the judge enters judgment. What we have here is different, and I think it's an important distinction. The judge entered a judgment, asked us to prepare what is essentially a ministerial document. When you read the case law on where quadros fall in, we did one that didn't comport with what she did. I think there's a good argument that's a case where the trial court judge gets to say, no, you have to do what I ruled. Now, in this case, I don't know that I can look at the final judgment and tell what she exactly meant. And I don't mean that to disparage a trial court judge, but I couldn't tell if it was accumulated or credited service. The method, she didn't use those words in there.
But the case law does not distinguish if it was at the direction of the trial court judge post her verdict after the bench trial.
I can't, I don't think so, Your Honor. I haven't researched that part, like I said earlier, necessarily. But on the other hand, that it concerns me that this court may issue an opinion that says that orders are signed as to form only are now constitute agreements between counsel before they're signed by the judge, because that's not what, I'll put it this way, that's not what trial counsel in the Washington and contiguous counties has fought for the last 15 years I've been practicing out there. And that means nothing. Y'all are the court, not me. I want to be clear. But I think that's a little bit of a dangerous road to go down. I'll leave it to the court to figure.
Why ask the question?
You did, Your Honor. So I always don't want to stick my foot in my mouth too much. I'm pretty good at it usually. But at any rate, I would like to, unless the court has some other questions on that issue, I would like to touch briefly, at least on the 4 minutes or so I have left here, touch on some issues in my cross appeal. I filed the cross appeal because I don't know, and I would argue to the court that the law on post-divorce divisions of property is not well developed. We can all state the rule pretty easily, what's in Chapter 9 of the Family Code, I think it's Section 203, that basically says if there's community property that was not divided in the original divorce, and there's a 2-year statute of limitations on this, if there's that community property, 2 years haven't passed yet, you can go back to the court that has jurisdiction, and there's even some other provisions for out of state and all, and you can ask them to divide the property. Simple, right? That's not hard to state. Conceptually, it's a pretty simple deal, but it gets a little stickier when it says, and the court, unsurprisingly to family law practitioners, is to divide it in a just and right manner and take into consideration things that ought to consider when there's children involved. So you get back to the issue of, well, what's a just and right division? We all know and can state that. I won't belabor that point here. But what it does raise, because while there are cases that discuss this, and there are cases that discuss It has to be community property that was in existence at the time of divorce. You don't get to divide something that didn't exist at that point, which is one of the issues I argue about here. But the other point that it raises, and it really creates problems with, is the opinions that are out there, both from this court, but mainly from the First Court of Appeals, and I've cited one of them, IRIC, in my brief. I think we both cited it. Those opinions, they usually give great discussion on it's a cumulative remedy with partitions, because after the divorce, the parties have become tenants in common, and whatever was undivided. Before the statute, there's partitions, we still do that. And they always make a point, almost every one of those opinions makes a very strong point about, oh, and by the way, res judicata still applies, unsurprisingly, to the divorce decree that came out of the first divorce. Then you get into issues, and this is where I think why I say the law is undeveloped. If I'm trying just a good old divorce, and we're not in a post-divorce situation yet, and there's adultery alleged, I'm going to argue for or against adultery as being a reason to move that just and right division around, to move off a dead center, to move off a 50-50. Well, if I'm now arguing post-judgment, and this is, the court can see in the record, this is some issue early on before we tried the case, if I'm coming post-judgment now, and I'm asking for a post-divorce petition of property based on a just and right division, do I get to raise issues like adultery at that point? Or did the divorce decree that was entered sometime before act as res judicata to that? It's important here because one of the issues that was raised, where I believe the trial court in its findings of fact and conclusions of law got to the $39,000 judgment against my client, is she said, well, the other party, there's a disparity of income, one of the factors that goes to just and right division. Well, to me, that's problematic because that's a res judicata problem. That's an issue that should have been determined in the divorce, in the original divorce. And so that's why I brought up that issue. And finally, and I've only got a few seconds here, this dovetails in with Justice Antu's questions, is very similar to the Rule 11 question she was asking about earlier. Here, when the proceeds from the marital property were divided at the title company, the parties signed an agreement. The agreement's in the record, it's attached to my brief, and I talked about it in my brief, and that's all the time I have.
All right, thank you, Counsel. Rebuttal?
Thank you, Your Honor. So it looks like I'm going about 100 different directions. There was no agreement at the title company. They're not a court of law. There was no agreement that was written into the court, into the decree. There wasn't one attached to it. It wasn't read in the court record. They simply asked, where do you want us to disperse these funds? And they would not split them any other way. Appellee even testified in trial court. Yeah, it could be a split-second decision. And yes, a lot of those documents came after the trial. Now, the judge didn't say, here's the judgment, write a quadro to it. She says, here's May 3rd. By May 10th, I want a proceeds brief, proceeds on the sale of the house, and I want a quadro. So the quadro was submitted, I believe, at the same time the proceeds brief was submitted, and that's when she sent this out saying, no, you're wrong. And those documents didn't come out until after we were out of the court, because we didn't know a lot of those things were going to happen with her changing the quadro. But it is allowed to be brought in as new evidence. It wasn't available to me. It's not a due diligence issue because I had no clue she was going to change it. And would it change the outcome? It absolutely would. If we had had the issue in trial court, would be able to explain, probably be confusing to the court as it would myself and Mr. Clover that know accumulated is 18 that they were married. That's the average. That's how we average. So it could have split it. We didn't bring up new evidence just off a whim. These are things that came to me afterwards, and I did my due diligence as soon as I got notification that, the quadro wasn't sent out as part of judge saying, hey, let me know what you think. The quadro was sent out with a judgment, and we read, and when I asked for findings and conclusions, she not only addressed the quadro, but she did address the disparities and the homesteading that she'd been there. My client had been there for, I believe, 55 months, paid $22,000 in. She also mentioned that the separate retirement accounts, the appellant took $13,000, the appellee took about $7,000, so it was another $6,000 to the appellee. Again, Mr. Clover states many cases about Rule 11. Well, I have the Rule 11 that he was talking about, and I read it to the court, to the justices here. unless there is an agreement. And that letter specifically said that he was okay with the way this was prepared, the preparation was correct, here you go, Judge, and that was it. And no, there was no issue. He mentions IRIC. IRIC is the case where in a post-divorce suit to divide property, the burden is on the party seeking the post, the plaintiff, and today the appellant. Established community property existed when the marriage was being dissolved and property was not divided by the court when rendering the final divorce decree. You can see the decree. It existed. They had a home in Hempstead. It existed and it wasn't divided. You know, that's what happens when pro se litigants, you know, that's what happened because of pro se litigants. It was divided. And further, there is a case, SC versus NB, which was the Texas Supreme Court 2022. At its core, subchapter C allows property that is no longer community property to be treated by a court as if it still were, so it can be divided by the just and right standard. The trial court made a just and right standard determination. She split the proceeds. Well, actually, if you read the trial court, the findings and conclusions and the judgment, she actually didn't address the proceeds. She just said, okay, considering the homesteading, and I believe my client makes 30% of what the appellee makes. That plus some other disparities, earning capacity, I believe $39,000 is correct, and that's 1%. If we went back and said, okay, of the sale of the proceeds, of the final total, which is nearly $800,000, she's got $39,000. We're talking about 1% more in the split. If we were to say this was an agreement, that they split 50-50, even though there was nothing written anywhere, even appellee's on a brief. We were to consider everything together. The appellant, 51%. The appellee got 49%. Not egregious. That's a just and right standard to me, considering she had owned the house prior and had made several improvements to the property. The Rule 11 is the Rule 11. And as far as your question earlier, got no clue when the appellee is going to retire. I believe he's late 60s. They were both cops. I don't see cops these days running the roads up into their 60s. It's tough. It's a young man's game. And what I see now is the appellee has buyer's remorse on signing off on that Rule 11. Any other questions, Your Honor?
All right, thank you, Counsel.
Thank you for your time.
Thank you for your arguments. 1424-00575 is submitted.
Thank you.
We'll take the next case whenever y'all are ready to go.
Thank you. Justices, by the way, this is my first time in front of the Board of Appeals. I appreciate y'all. Appreciate your hospitality.
Good. Yep.
Can you bring those Kleenexes up here for just 1 second?
Yes, please.
Swipe it over. Thank you. Did you want 5 minutes for rebuttal, Mr. Gill?
3 minutes.
3, okay.
Yes, sir.
May it please the court. My name is Anthony Goals. I represent the appellant Williams Brothers. In my time today, I'd like to address perhaps 3 issues, if I have time. The first issue cuts right to the heart of the matter. It's the issue of Williams Brothers' compliance with the applicable contract documents at the time of the plaintiff's accident.
Counsel?
Yes, Your Honor.
Did you receive the notice from the Harris County District Clerk's Office that the contract didn't make it here?
I did, and we're dealing with that now. Yesterday, what we've done, my colleagues have been gracious enough to stipulate that the contract that was filed, we attempted to file it yesterday. The district clerk kicked it back this morning and said we needed to attach a cover letter. So today, we have filed the contract into the clerk's record. I need to amend the request to supplement the clerk's record, which I will do when I go back to the office. I filed one yesterday afternoon. So the court should have the contract shortly. So, back to my first point with the issue of Williams Brothers contract compliance. 3 points I'd like to address on this issue. First of all, we cited in our briefing what we think is the controlling contract provision here. It's item 5.1, which clearly states that the engineer decides all questions about contract interpretations and acceptable contract fulfillment. This was the same provision at issue in the case law that we've cited, 2 opinions that we think should be not controlling, but certainly persuasive here. It's the Markham opinion from the San Antonio Court of Appeals and the R.K. Hall opinion from the Texarkana Court. Both of those cases also involve that same contract provision and involve testimony by the engineer in those cases. Here we also have the TxDOT engineer who testified. Her name is Melody Gallant. She is the Southeast Area Engineer for TxDOT, and for the purpose of item 5.1, she is the engineer who decides all questions about how the contract is to be interpreted and about whether Williams Brothers complied with it or not. We have unrebutted, uncontroverted testimony from Gallant after her review. She didn't just come into the deposition and say, yeah, I think they complied. She sat down with her team, had a meeting with her team, and went over the project record, went over the photographs of the scene of the plaintiff's accident, went over the contract documents, went over all, and this is critical here. There were 2 teams of inspectors working under her, right? There was the TxDOT crew working for her. There was also the Volkert crew, which was a contractor for TxDOT. The job of those inspectors was to determine whether or not Williams Brothers in fact was complying, not just with the traffic control plan, but with all the contract documents. And critical to the court's decision today, and frankly what the plaintiffs cannot overcome, is she said that she went over the entire project record, the documents she was presented, could not find a single document indicating that Williams Brothers was not in compliance with the contract. And that's fatal to their argument. That's what brings this case closer to the Markham opinion and closer to R.K. Hall, is that she did a diligent review. She sat down with her team and she scrutinized this particular issue. Also, during her deposition, she was specifically asked about this very work, not generally about whether or not they generally complied. She was asked about the use and the placement of stripes and buttons at the scene of the accident, and specifically whether it was a minor field adjustment or whether it was in fact a major transition that would require a new traffic control plan. She specifically said no.
If it was a minor field adjustment, did the contract allow for Williams Brother, with the engineer's permission, to do that?
Yes. We have cited in our reply brief the provisions of the contract which corroborate Gallant's testimony. And they are, it's item 502 of the TxDOT specifications that was incorporated into the contract. I think we quoted it in our reply brief, but it's item 502.2a. And about in the middle of that provision, it states, minor adjustments to meet field constructability and visibility are allowed.
So
And
is there not a question about whether that's a minor adjustment?
no, because she is the only representative, frankly, from anyone, but certainly from TxDOT, who is empowered to make that determination. Now, critically here, they have proffered a testimony from their expert, David Hall, who relies on chiefly the engineer's testimony, the engineer Edwin Ho, who did the original, the original revised traffic control plan. Importantly, Ho deferred to Gallant on these issues, right? He was specifically asked, and again, we've cited this testimony in both our summary judgment reply and in our reply brief, and it's page 2135 of the record. Ho was specifically asked, Now, we've been talking about the low-profile concrete barrier, putting it down, not putting it down. If it's on the original plan and is to be taken off and not installed, that is a major change, correct? And Ho says whether or not it's a major or minor change, I believe, is up to the area engineer, which is Galland. And goes on and on. He specifically asked whether or not this was major or minor, and in all instances, he deferred to the engineer, the area engineer, which would be Galland here, and she's the only one empowered to make this determination.
But how is that not a question of material fact?
There's no contrary evidence on that point. To have the fact issue, we'd have to have some evidence here and some evidence here, right? If Galland, so 2 points on that. First of all, under the contract, and that's the importance of item 5.1. 5.1 says the engineer, who is Galland, is the only person who decides these issues. So we have her testimony. We also have, and we argued in our briefing, the contract construction rule, which states that whether, when you have an unambiguous contract, you can't admit extrinsic testimony to interpret its terms, right? We also have that argument too. We pointed out that that rule would bar any inconsistent testimony from any other witness, except for Galland on this point. And again, Galland was specifically asked this issue, this very work, whether it was major and minor, and she says it's minor.
So help me understand this. Even if it was minor and didn't require something in writing, isn't there some sort of conflict between whether there was a conversation of verbally approving this modification?
You're asking whether there's conflicting evidence on that point?
Mm-hmm.
No, not at all. We have uncontroverted evidence from Williams Brothers chief surveyor, Mike Honeycutt. Mike Honeycutt is the witness who testified that he personally observed Lloyd Pierce, who was the head inspector for, I mentioned Volkert earlier. He personally observed Pierce pick up the phone, call someone over at TxDOT, and got a verbal approval before the stripes and buttons were laid down.
Did Mr. Pierce give any evidence?
Pierce was deposed. Pierce said he couldn't remember. Pierce was asked whether he was saying that the call never happened, and he said, no, I'm not saying that. I'm just saying I don't remember it like Honeycutt did. And then Pierce was asked, did you find Honeycutt to be an honest and straightforward guy? And he said, yeah. We have, in City of Keller, the Supreme Court said that just because you have undisputed evidence doesn't mean that it's conclusive. But here you would have to have some evidence to support finding that the call never happened. And again, Pierce refused to say that it didn't happen. He just said he didn't remember it. And if you think about Galland's testimony and think about the course of this entire project, this was a minor change on one of several jobs that were ongoing at the time, right? I looked through the record. I couldn't see any indication of how many jobs were going on in the Southeast area region at this time. Galland was asked how many jobs were going on in that area involving Williams Brothers, and she said 4. So use that as a baseline. It's a relatively minor change on one of many jobs. That supports the status of the record in terms of nobody having documentation on the verbal approval. Certainly, because it was a routine thing. Even the Supreme Court, in its Christ opinion, stated that the use of painted stripes and buttons to separate travel lanes on roadways is ordinary, commonplace, and standard engineering practice. It was a substitution of stripes and buttons for low-profile concrete barriers on a part of the job. It's a minor change, again, according to the only person at TxDOT empowered to determine the matter.
So your argument is, she says it's minor, so it's minor, period, end of all inquiry.
I think
right.
That's right, and that certainly would be true even in the face of contrary evidence, but there isn't any contrary
well, what's
evidence
the
here.
limit of that authority? When does a court get to step in and interpret it? I mean, it could be a minor change to turn the concrete barriers perpendicular to the roadway. She says it's a minor change, but...
Right, I mean, you'd have to look at all the, it would be probably impossible to give like a hard and fast rule on this. But certainly something like this, I mean, all the objective facts and circumstances support that this is an ordinary lane delineation device, right? And so it's not like they're removing all traffic controls from the roadway, which, I would think that would be something a little bit more significant if they just said, you know what, we don't need anything on the road. But again, and this wasn't even a substitution for the entire length of the roadway. It was just based upon field conditions, which again, Galland testified happens all the time. When what's on the plans doesn't match what's in the field. And the contractors have to be able to work to address these field conditions and get the project done expeditiously. And the important thing to remember here on this is it's not like the accident happened right after the stripes and buttons were placed, right? According to the record, they were there for about 4 months. And the Supreme Court found this significant in its opinion. There was not a single complaint or another accident before the time of the plaintiff's accident. And that was one of the factors.
Follow up to Judge Bridges' question, because I read the Christ opinion, and it appears that the Supreme Court believed that the dispute of the parties was whether TxDOT orally approved the change or not.
Should I answer?
Sure.
Okay. If you look at the underlying briefing, and we pointed this out in our summary judgment in our appellate briefing in this case, we contend there's a judicial admission, a clear judicial admission by the plaintiffs that there was verbal approval. If you look at their response to TxDOT's plea to the jurisdiction, and you can ask plaintiffs' counsel how this is not a judicial admission, but if this isn't a judicial admission, I don't know what is. Their own words, these are their words, not ours. This comes from, it's page 1620 of the clerk's record. They say, there is no question that a second verbal traffic control plan was created between TxDOT and Williams Brothers. There is no question? How is that not a judicial admission? But even beyond that statement, and we've quoted others, look, and we've included their briefing as summary judgment exhibits, look at their response to the plea to the jurisdiction and look at their brief to the Court of Appeals. The necessary position that they took before both courts was that TxDOT willingly allowed its traffic control plan to be deviated from. There was 2 components to their argument, and they had to make this argument under the Tort Claims Act. It was their position that TxDOT knew of the changes and either expressly or tacitly approved of them. And again, they had to demonstrate this in order to create a fact issue on their Tort Claims Act claim. Right? So they have admitted at a minimum that TxDOT knew and approved of the change as of the time of the accident. I think what they're quibbling with is whether there was a verbal approval before the stripes and buttons were placed. At a minimum, though, based on the position that they've taken in this case already, they've admitted that TxDOT knew and approved of the use of stripes and buttons as of the time of the accident. And I think that's all my time.
Knew, but also approved? You're saying the plaintiffs went as far as to admit that not only did they knew and approved, but approved of the change that your client took?
But yeah, I think that's a fair estimate of their pleadings. And TxDOT pointed this out in its appellate briefing. They kind of went back and forth on this. In some parts of their briefing, they would say that the verbal approval was given, and in other times they would play coy. But at the end of the day, if you look at the portions that we've cited in our briefing of their previous filings, they took the position in some parts of their briefing that there was express approval, and they took the position in other parts that it was tacit approval. Either way, approval is approval. And importantly on this point, TxDOT itself took the position that it knew about all these things too. TxDOT said in its filings, TxDOT says, of course TxDOT knew of the condition. TxDOT directed the placement of lane delineation as part of the road construction project. That's page 1686 of the record. Page 1668 of the record, TxDOT says it was TxDOT's choice to use a double row of striping and yellow reflective buttons. Right? And they had to make this position, right? Well, I'd say they had to. It was their position, TxDOT's position in the appeal, that this was a discretionary design decision, right? They made the deliberate discretionary choice to substitute one lane delineation advice for the other. So we've got TxDOT's clear position on this issue, and I think there's enough to bind the plaintiffs to their position that they took in their previous filings in this case.
All right. Thank you, John.
Thank you.
Good afternoon. May it please the court. Scott Cummings on behalf of the appellees. At the heart of this case, it's really about burden of proof of compliance with a contract document. And all that you have heard from the appellants are excuses for why they didn't comply with the contract documents, why somehow they were allowed to not comply. I want to take us back to the contract documents that they were required to show compliance with. In this interlocutory appeal, where the only issue before us is contract compliance, Williams Brothers has the burden of proving they complied with the specific traffic control plan that was designated by the engineer Ho. And by the way, you heard a lot of comments about Melody Galland. Ms. Galland testified that on the issues with respect to the TCP, she actually defers to Edwin Ho, who created it. And as Your Honor pointed out, this is the real issue here and why we have fact issues on so many different points here and why the trial judge appropriately denied summary judgment. Edwin Ho's TCP required 460-some feet of low-profile concrete barriers. And there's a very basic reason why that was required. The way that this intersection was working, if you didn't have something preventing traffic that was heading right into each other from moving into each other, you were going to eventually have an accident. Edwin Ho saw this, he recognized it, he required low-profile concrete barriers, and Williams Brothers unilaterally made a decision to remove those. Not just to remove the low-profile concrete barriers, though, but also to move the lanes a little bit. And so when you get to contract compliance, the first thing you look at is, well, what did the TCP require? The TCP required low-profile concrete barriers. There's absolutely no question they were not in compliance with the contract documents.
Is there anything in the contract that allowed Williams Brothers to deviate, as they say, if the deviation was a minor adjustment?
So the question then becomes, did they have an ability under the contract? Your Honor is absolutely correct. There are a couple of things that I want to point you to. First and foremost, everyone agrees if this is a major deviation, then you've got to follow through with getting a new signed and sealed plan. But I want to point this out. The contract doesn't actually distinguish between minor and major. The contract says if you're going to change the TCP, you've got to go get a new signed, sealed TCP. That's what the contract required. And appellants never challenge. They don't suggest, hey, wait a minute, the contract actually gives us this off-ramp. They just ignore it. They go into this whole minor field adjustment. But the contract itself doesn't allow for this sort of oral change. But now, let's take the next step. Let's assume that the court determines, okay, if it's going to be a minor field adjustment, we might allow for an oral change. Well, here's your issue there. First of all, you've got an incredible fact issue whether this is a major versus a minor deviation.
Why? They say you don't because you didn't have any evidence.
Well, they say we don't because Melody Galland says we don't.
But he
first
said
off,
there's no contrary evidence.
Well,
What's the
I
contrary
disagree.
evidence?
I apologize for interrupting, Your Honor.
All right.
Respectfully, we disagree, Your Honor. There is testimony from Mr. Ho talking about this being a major change. There's testimony from other witnesses setting forth. And this is the very
What other
essence.
witnesses?
Your Honor, I would have to go back. I believe it's the, and I'm getting some of these names wrong, and I apologize. It's Mr. Embeal is also one of the ones who talked about this being a major change. Our expert, Mr. Hall, talks about this being a major change. Yes,
I don't
Your
think
Honor.
that addressed, or at least that didn't answer the question I thought that Justice Wise gave. Who is the person who contradicts the gentleman who was there for the phone conversation with Mr. Pierce?
Sure. So I would say first and foremost, Mr. Pierce says that his recollection of that conversation is different. That in and of itself raises a fact issue. The other problem we have is we have no idea who this is at TxDOT that answered that call. For us to be able to say TxDOT gave approval because Mr. Honeycutt claims he heard Mr. Pierce talk to someone at TxDOT, unidentified, unknown, as we point out in our brief, reductio ad absurdum. Is he talking to a janitor there at TxDOT? How can that be sufficient evidence to overcome a fact issue? And that's all we're at here right now. A fact issue of whether or not there even was approval. And that's if you even get past the fact that the contract doesn't allow for oral approval. So you already got a fact issue before we even get to all of this talk about this phone call. And there's obviously a dispute with respect to the phone call itself. Even if we accept, and one step beyond that is, even if you accept that they were talking to someone at TxDOT who could give approval, you've got a fact issue whether this is a major or a minor change. And Mr. Embeal says major change, Mr. Ho says major change, our expert Mr. Hall says major change. That's certainly enough for us to get to a jury with respect to those issues. And when we come back to the contract documents, there is clear evidence to raise a fact issue with respect to that. And at the end of the day, one of the things that's frankly plainly clear is there's no dispute The traffic control plan that was signed and sealed did require the low-profile concrete barriers. Now, I want to go back to something that Justice Antu asked, which was about how the Supreme Court characterized that issue of a dispute between the parties. And Your Honor, you're absolutely correct. At page 85 of the Christ opinion, the Supreme Court writes of that issue, all agree that TxDOT never approved the revised plan in writing, but the parties dispute whether TxDOT approved the change. And I presume that's what Your Honor was referring to when you said the Supreme Court recognized that there was a dispute with respect to oral approval. The appellees have always disputed whether oral approval could be given, whether it was appropriate, and whether it was in fact given. Now, the other thing that I would suggest is, and we've cited the case law in our brief, in order for it to be a judicial mission, it's got to be clear, positive, direct. What you have in this case is taking some statements that we believe are being taken out of context in an attempt to get out from under the obligations under the contract. Let me say three things on that. Number one, the appellees cannot admit away the legal obligations of the appellant. They can't say, well, you've admitted this occurred, therefore we don't have to follow our obligations under the contract. Further, the appellees cannot admit away what the law required the appellants to do. All of this, Your Honors, is an excuse. It's a way to try to get out from what they know, which is that there is a fact issue with respect to compliance on the contract. They unilaterally amended it, and we know why they unilaterally amended it. They unilaterally amended it because they were running behind. There's evidence in the record, and one of the things that I found quite interesting was one of the notes that's in the contract DWR summary, and this is at page 2440 of the clerk's record. Mr. Honeycutt is talking about it, and they're talking about how they're going to do this transition, and this is a note that Mr. Pierce writes. Mike stated that he knew it was not the cleanest, and this was due to the hurry of completion for opening. Williams Brothers is in a hurry. They want to get this done. It's a massive contract. They are cutting corners. And they're cutting corners by not complying with the contract, or at a minimum, not complying with what the contract required them to do. And Your Honor is correct. The contract set forth a way in which they could propose changes to the TCP. If you look, for example, and we did include some oral argument exhibits just so that we could help the court. If you look at Exhibit 6, which is the Barricade and Construction Standard Sheets General Notes. The third note says that the contractor may propose changes to the TCP that are signed and sealed by a licensed professional engineer for approval. The engineer may develop, sign, and seal contractor proposed changes. That's Mr. Ho's TCP. In other words, the contract contemplated the very scenario that might have occurred here. Williams Brothers wants to make a change. They can't just unilaterally go and do it.
But to their point, Melody approved the change.
Well,
why is that not?
Ms. Gallen wasn't even at the scene for during this period of time. And we're talking about, and by the way, the cases, Markham in particular, were after work was completed acceptance. If you go out to Bay Area Boulevard right now, there's a huge concrete bunch of bricks separating these lanes. So Melody Gallen's ex post facto statement that she would have approved it, first of all, that's a fact issue in and of itself. She can't say on the day that the incident occurred it was going to be approved, and certainly not ex post facto in a deposition. What we're going to look at is what was in place at the time. And you're not allowed to alter. And in fact, one of the things that Mr. Ho testified to, one of the things that the contractor that the contract discusses is that you're not allowed to change the contract, that the inspectors, the individuals, are not allowed to change the terms of the contract. And let me see if I can find that quote for your honors. Yeah, it's at 2 CR 2134, right? Where Mr. Ho testified, inspectors cannot alter, add, or waive contract provisions. Inspection or lack of inspection will not relieve contractor from the obligation to provide materials or perform the work in accordance with the contract. Your Honor made a point, and I forget if it was Justice Wise or Justice Antu. What if Williams Brothers turned the low-profile concrete barriers parallel, and Ms. Gallen said, you know what, minor adjustment, I'm good. Well, what if Ms. Gallen says the sky is purple? At some point, there has to be a limit on what sort of ex post facto TxDOT approval can be out there, particularly where in this instance, there is no question there was a violation of what the contract required Certainly no question of a fact issue. And that's what's before the court right now. Let them make this argument to the jury. That's what juries are for. In this instance, you have fact issues regarding compliance. You have fact issues regarding approval, regarding whether or not this work was going to be able to pass inspection or not. Let's go talk to a jury. We're
Yes,
still at
their position with Ms. Gallant is that she testified that there was no document indicating Williams Brothers was not in compliance with the TxDOT contract. And so that would mean there's no issue of fact left.
Respectfully, I disagree. We've got the red line drawings that change up the TCP. That's clearly a disputed fact with respect to whether or not they are no longer in compliance with the contract. Ms. Gallant is not a judge. Ms. Gallant doesn't get to sit up there and say as a matter of law they were in compliance with the contract. There are fact issues with respect to that compliance that are as basic as the contract says you have to have them, they didn't have them. From my perspective, Your Honors, the most basic fact here is the contract required low-profile concrete barriers. Williams Brothers failed to put them there. That creates a fact issue of compliance with the contract. Now, we have all of these other fact issues, and I think we spend almost 8 pages of our brief listing out 31 different areas of fact issues that came up with respect to all of the different issues here. And I've only got 3 minutes left, so I won't go through all of them, but
Let me ask you a quick question. Did the trial court judge review the contract prior to her ruling or his ruling?
I was not at the hearing. The contract was Exhibit C, I believe, to the motion for summary judgment. So the contract was in the summary judgment record. It's 2,400 and some pages, but we can presume that the trial court judge looked at the summary judgment record before his ruling. And I want to address one quick thing on that point so that I don't forget it. There's an argument before this court that the law of the case and some of these other things are before the court because of a one-order issue, and we sort of dealt with that in our SIR reply. But I want to make a point. There was also a no evidence motion for summary judgment before the trial court. And when you look at the trial court's order, and the trial court's order is over on, I believe it's 3 CR 3028, you'll see that the order denies not just the traditional motion for summary judgment, but also the no evidence motion for summary judgment. And so a lot of what your honors are talking about, was there evidence of this? Was there evidence of that? The appellants made a no evidence motion for summary judgment. That would not be properly before this court because it's not part of that 97002 defense. But with respect to this argument that because you have one order denying a traditional summary judgment motion, therefore we're entitled to get into the issue of law of the case, appellants don't even presume to tell the court, oh, and we also got our no evidence motion. But if you take their argument to its logical extreme, you'd have to say that the no evidence motion would also be before this court, and that would eviscerate the jurisdiction rules. It would eviscerate 51014A17 and what it does and does not permit. So I want to make sure that I at least address that at the very end, because I think there's 2 quick and very easy ways for this court to dispose of this matter. First and foremost, there are fact issues on the 97002 defense. That needs to be determined by a jury on so many different levels. Second, with respect to any of these other arguments, they're really not properly before the court. You know, the reason that this is here is an interlocutory appeal. This is not an appeal of the final judgment. It's not an appeal of a summary judgment granting in full all of these various issues. All that's in front of you is the 97002 portion, and the court should stay limited to that, limited to the question of contract compliance, and all of this other stuff is really just sort of raising issues that are not properly before the court. At the end of the day, I want to end with this point. The purpose of a traffic control plan is the safety of the driving public. Edwin Ho, who developed this plan and whose testimony is cited throughout our brief, told the driving public, or told Williams Brothers, that the driving public needed to be protected by these LPCBs. He recognized that a collision like this could occur. He recognized it needed to be addressed. Williams Brothers chose to ignore that, chose to ignore his traffic control plan, unilaterally did what they did without approval, and that caused this collision. And frankly, Mr. Christ and Ms. Salinas are entitled to their day in court on it. Thank you, Your Honors.
Thank you, Counsel. Rebuttal.
Your Honors, if I may have 20 seconds. This is on that Austin materials that you had.
I'm sorry.
Yeah. Your Honors, in preparing for oral argument, and I've discussed with Mr. Goals, and he actually mentioned that he might bring up this case as well. I just want to draw Your Honors' attention to the case of Austin Materials versus Rosado. It was an unreported case. We found it while we were getting ready for oral argument. The Westlaw site is 2023 Westlaw 3666107. That case deals with a lot of the issues.
Could you say that again for me?
Sure.
This one?
It's 2023 Westlaw 3666107, and it is a petition denied out of the Austin Court of Appeals. I thank Your Honors, and I thank Mr. Goals for letting me step in.
Let me begin with, there's no basis to infer that the contract was not before the trial court when it ruled. It was submitted to the court per the trial court clerk's direction for us to email it rather than file it. It was served upon opposing. This issue never arose until I reviewed the clerk's record and determined, oh, it was emailed rather than filed, but the presumption is that the trial court clerk would have presented it to the judge, and there's no basis for this court to infer otherwise. And if the court's inclined maybe to hold that it wasn't, I would ask that we be permitted to file additional briefing on the issue. Let me begin by addressing what my colleague said during his presentation. He first claimed that, he claimed that the contract does not distinguish between major and minor changes to a traffic control plan, and that is false. We pointed out in our reply brief the provisions, and Your Honor, I cited one of them to you during my presentation, which it was page 1255 of the clerk's record. It's item 502.2A, and it talks about compliance with the traffic control plan. And in the middle of the provision, it states, do not make changes to the location of any device or implement any other changes to the traffic control plan without the approval of the engineer. It says nothing about writing, just says approval. Also says minor adjustments to meet field constructability and visibility are allowed. There is the distinction between major and minor. Also pointed out in our reply brief on page 474 of the record, this is table 1 to item 5.2. And it creates a table, and in item 5.2 it says, have a licensed professional engineer sign, seal, and date the working drawings as indicated in table 1. If you look at the bottom of table 1, it says that only contractor proposed major modifications to traffic control plans will require us to obtain a licensed engineer seal before we submit the changes to TxDOT.
Where in the contract does it say, or it allows you to make the oral change you suggest you are allowed to make?
There is only one provision that addresses the issue of written approval, and the other side has relied on it in their briefing. It looks like it's paid, well, I don't have the, let me see if I have their site.
You could just read it to the court, that's fine.
It says, any revision to the plan, any revision to the traffic control plan which would alter the existing traffic lanes in an operation will require approval of the engineer in writing and will not be implemented without written approval. That's the only provision of the contract that addresses the issue of written approval from TxDOT. And it says, and again, Galland testified, and TxDOT has said that that provision was inapplicable. Now you've got to look at the contract in its entirety. You've got to harmonize all the provisions. You can't rely on one to the exclusion of the others. And again, Galland testified about minor adjustments to meet field constructability. She said that that's exactly what this is. And again, her decision on that issue ought to be conclusive. There is no contrary evidence that the court can credit that says that this is major or minor, or this is major instead of minor, like she said. So we think that the evidence conclusively establishes our entitlement to summary judgment under 97002, and we would ask that the court reverse and render.
Thank you, counsel. Thank you for those excellent arguments. 14-24-00626 is submitted, and we're adjourned. All right.